It's good to see you here. We've got an in-person event. I recall 12 months ago that we were scheduled to have an in-person event. And then, of course, the government at that time, which I think was three prime ministers ago, the government at that time determined that the incidence of COVID was such that it was not appropriate for there to be significant social gatherings. And I take this to be a social gathering, whether it would count as a party in Downing Street, I'm not going to say. But that meant that we moved from having an in-person event to an online event at the drop of a hat with the expertise of our marketing team. And much to their credit, we were able to do that. But of course, we missed the interaction with you. So you're all very welcome. It's very good to see you here this evening. Thank you for coming. A couple of housekeeping measures, and then I will go on to introduce our speakers this evening. Please, as a courtesy to the speakers and to other members of the audience, if you do have anything which is likely to beep, please switch to non-beep. As you may choose to, whether that is aircraft mode or anything other mode. So please don't be there. Secondly, it is not expected that there will be any fire alarm this evening, but we never know. Yesterday, by way of comparison, yesterday morning we had our weekly fire test or fire alarm test. That did not go according to plan. So mid-afternoon we had another one. Which was some of us a little bit of a surprise. Okay, so that's by way of housekeeping. Should it happen that there is a fire alarm, not expected, but should it happen, we will show you how to leave the building in a safe manner. So no worries there. Sorry. Right, moving on. Our speakers this evening. So we've got 4 speakers, 3 members of our fashion law group who have been kindly volunteered, no pretend, to speak to you this evening. Our first speaker will be Rebecca. She's going to be talking about turnover rents. As some of you will have seen from the trade press over the last few months, there is certainly an uptick in the number of new leases, number of new retail leases that are being taken. Whether any of them involve turnover rents, whether turnover rents are allowed in the Battersea power development, I have no idea. Rebecca may be able to update us on that. Rebecca's going to be followed by Francis, who's our guest speaker this evening. Francis is going to be talking about remuneration and reward for senior employees. It is the case, as all of us will know, that we are expecting to face something of an economic downturn over the course of the next 12 months. However, I suspect where we will be for senior employees and those who can really move businesses forward, that they will continue to command a premium in the market. And I anticipate, Francis, that we'll be letting us know whether what I've just said is true or not. Chinwei is then going to be talking about director responsibility, arguably the other side of the coin. As life becomes more difficult for many businesses, the pressure on directors to perform and to observe their legal requirements and avoid being personally liable, that I think is going to come to the fore. And then lastly, Vlad is going to be talking about key issues brands looking to launch NFT collections, which, as I want to wind Vlad up from time to time, apologies, Vlad, I'm sure it's out as well, but it might be a film somewhere. Right, without further ado, let me pass over to Rebecca. Q&A will be possible at the end of all of the speakers' talks to you this evening. And then after the Q&A, we will move back across and there will be some more drinks available. There will be canapes available. You'll be able to network and you'll be able to ask one-on-one questions of our speakers. Rebecca, over to you.
Thank you, Steve, and hi everybody and welcome. So as Steve mentioned, I'll be discussing turnover rents. Here's a bit of an agenda. So we'll talk about what turnover rents actually are in retail leases, why they're relevant today, pitfalls to avoid, and a few takeaways on the finish. So what is a turnover rent in a retail lease? It's essentially an alternative to a market rent lease. So it's based on the income that the tenant makes at that particular location. So the tenant will pay a percentage of its gross turnover made at that leased property to the landlord as rent for its use of that premises. So by their nature, they're very much uncertain, subject to change, potentially upwards or downwards annually, depending on the market. Whereas the market rented, what we call rack rent lease, would generally move on an upwards only basis, particularly at the moment. So that's what a turnover rent is. How are they determined? There's usually one of two standard models used. The first one being what we call a pure turnover rent. So that's where the whole of the rent is calculated by a percentage, usually somewhere between, say, 5 and 12% of the tenant's annual turnover. This is less common, certainly less favoured by landlords. The other more commonly used model is what we call a top-up turnover rent lease, where you will have a minimum base rent that's always going to be payable every year. That's set usually somewhere around 20% below market rent. That would then be topped up by a fixed percentage of the annual turnover of the tenant, so far as it's over and above that base rent, so it gives the landlord a bit more certainty. So they're the most straightforward models. The whole concept of having a turnover rent is that it departs from that rigid structure of a rack rented lease that market rent is. So it allows us some flexibility and creativity. We don't have time today to go into all the potential options that you might have to determine what your turnover rent looks like, but we can discuss it later if anybody's interested. So why is it relevant? Why are we talking about this today? Turnover rents aren't a new thing. They have been quite common in the past and still are generally in places like shopping centres, outlet villages, anywhere really where the landlord has substantial control over common parts and amenities in the vicinity of the property. What we're seeing, particularly here at Fox Williams in our real estate practice, where we act for both landlords and tenants, is our landlord clients in particular are now really being driven to use turnover rents much more frequently on high street stores as well as in these outlets and centres. Crucially for the landlord, it means that they're not left with a void unit. A void unit means that they have to pay business rates themselves. So at least with a turnover rent lease, even if there's no real turnover being made, there will be some tenant obligations, usually to keep the premises in repair. There will usually be insurance, rent payable, service charges payable. In COVID, we saw quite a few company voluntary arrangements, CVAs, which has resulted in a few household names. So New Look and All Saints are an example. They moved all of their leases to a turnover model as a result of the CVA. We're obviously now back in recession. Jewels have been in the press recently, so it does look likely that there will be further moves towards turnover rents again. Certainly calls from tenants. It's not all bad news. There are some benefits to turnover rents. So it's a collateral benefit really, in that it saves jobs, it keeps those household brands in the high street, which is dear to the public. There's also a resulting collaborative relationship between the landlord and tenant, which traditionally hasn't really been the case. It tends to be slightly adversarial. But of course, now with a turnover rent, the landlord's very much invested in that store. They want it to be profitable. So whilst they might be sharing in the tenant's pains, they're also sharing in the gains when times get better. From the retailer's point of view, they get a rent tracked to their profitability and the landlord who's invested in the success of the store. So it seems like a bit of a no-brainer, but there are a few pitfalls and traps that you probably just want to watch out for. So the one key item to get right really is what we define as being included in the meaning of your gross turnover for the purposes of what's going to then be payable to the landlord under your lease. So what items can we factor in and therefore essentially inflate the rent, and what can be excluded to bring it down? And here we're very much talking about gross turnover as opposed to profit. It might be that sometime in the future we start looking more towards profit, but it's certainly not where we're seeing the market at the moment, and likely resistance from landlords at least. So when calculating gross turnover, we essentially mean all sums that come in or from that premises by the retailer. So it would include payments made to others. So say you're subletting or you've got concessionaires in the premises, it would all essentially flow up to the landlord. It also generally includes ancillary charges, so things like delivery, postage, and also usually the full value sale price of anything where staff discounts or rewards are given. The commonly deducted items are VAT and other sales taxes imposed, and also any refunds given to customers for returned goods. So they're clearly settled. The items that are causing the biggest headaches at the moment are online sales, and in particular click and collect, which is just causing everyone a headache at the moment. Landlords generally are always going to push for click and collect items to be included in the gross turnover, where they're collected from that particular store, even if you as the retailer are only seeing that store as essentially a post box for what you see as an online sale only. There could also be some discussions around online orders where that store is used essentially as a showroom, so perhaps the goods are delivered from a warehouse elsewhere. And what we've seen is the more creative the industry gets as a response to customer demands, the more difficult it is to track a sale and pin it to a particular store for the purposes of calculating the rent. The landlords are definitely looking for ways around this, generally using technology, which can be expensive and difficult to get hold of. And also, some tenants just don't have the bandwidth to assist landlords with this. So in these cases, you do get a bit of friction, and landlords may then start to be pushing for a higher turnover percentage to compensate for what they're essentially seeing as a lost online sale that they want to really related to that particular store. Another resistance is the administrative burden side of having the turnover rent, and also retailers' concerns about the confidentiality of their data. So they're handing all of this information to their landlord. Where is it going from there? So it's important that your leases deal with this. Landlords are generally going to push for fairly watertight accounting mechanisms in the lease itself. With tenants' accounts, they'll want them to be externally audited. They'll want regular reporting back to the landlord and disclosure. So the key really is to make sure that if you're negotiating a turnover rent lease, that it actually works for you and your business. The amount of times we see provisions go in a lease that kind of turns around and says, well, I can't do that, I don't have that technology, or I don't want to hand this over. So what we see is really important for us when we're doing our job is that we have the right personnel at the retailer speaking with us and speaking with their advisors, so it works on the ground going forward. A few other lease provisions just to watch out for where you do have a turnover rent lease. Keep open clauses. They're, again, not really anything new, but particularly prevalent in turnover rent leases. It was quite normal to have them. So if you close when you shouldn't be closed as a retailer in normal business hours, you would be paying a notional rent to the landlord, which would be equivalent to what you would be paying if you were open. Important going forward in the post-COVID world that we carve out any forced closures. So if it's not the retailer's choice to close, then they shouldn't have these sorts of obligations in the lease to pay a notional rent to the landlord. Break rights for landlords, another one to watch out for. It's more common in these types of leases that a landlord would want the ability to end the lease early if the turnover isn't resulting in what they're expecting. So just be careful if you find yourself agreeing to this, because you could be out of the premises sooner than you like. It's very much a point of negotiation at the start, so depending where the bargaining power is. Another important point, it seems really obvious, but check that it actually works for you. Do you want this type of rent? Could the market rent actually be better? I'll put this JD Sports close up on the screen just as a point of interest. So it was decided in the court last year, 2021. It actually took 4 years to get a decision in the court, so it was emanating from 2017. JD Sports were negotiating their renewal lease. It's an existing lease that they wanted to continue. The existing leases on a turnover rent basis, and their starting position was that they wanted that to continue. Let's have a turnover rent lease going forward, please. Landlord said, no, back to market rent, please. We're starting afresh because we're having a new lease. They couldn't decide, or they couldn't agree. So it went to court to decide what the rent should look like. As it happens, when they both took advice, the landlord and tenant switched positions. JD Sports said, actually, I'll have market rent, please. Landlord said, no, you got a turnover rent now, let's keep that. So it got fought, which is probably part of why it took 4 years to get decided. The court's position was very much, we don't really want to depart from anything that's not market standard. So they eventually imposed a market rent. So in favour of the tenant, which is a nice decision from a retailer's point of view, JD Sports rent went from around £500,000 per annum on the turnover basis to around £100,000 per annum on the fixed market rent for the new term. So it was worth having that argument in court and the time it took to get there. The lesson really for everyone is just check that what you're asking for, agreeing, is actually what you want. So with that said, you might still be keen on getting yourself a turnover rent. So how do you go about doing it? If you've got an existing lease, check to see if there's any break rights coming up, or perhaps you're coming up in a couple of years to renewal. That's a good opportunity for you to start leveraging your break perhaps, or your new term with your landlord, a good point to start negotiations. If you're taking on a new store, a brand new lease, get yourself a good agent, surveyor, discuss your options early, and go in the negotiations hard if you can. If you're taking an assignment of an existing lease, so you've got an outgoing tenant leaving premises, but you're taking on the tail end of their lease, if it has turnover rent provisions in it, it's possible that they're personal to that particular tenant because they're so bespoke. So just one to watch out for. You might, on the face of it, just think you're taking over a turnover rent, but it might automatically, in the detail, revert back to a market rent. So just one to check. You might at that point be able to renegotiate something with that landlord. Perhaps you have no new lease events coming up, so you're just smack bang in the middle of a long term. Perhaps if you've got a break in there, might be a few years down the line, you could use that to leverage, say, I'll forego my break, so I'm here for longer, or perhaps you'll agree a renewal. So extend your term of your lease, even though you're not coming up to the end of it. So the landlord is getting a good amount of security from you staying on, and you might be able to use that as leverage to change the terms of your existing lease. So that's a bit of a whiz through quite a complex topic, and I've just tried to cover the main bits as quickly as possible. Don't expect it all to be committed to memory, so I've just put a few takeaways here that I think are the most important things to remember going forward. So number one, understand the detail. It is quite complex, but it's really important that you get it right and you know what you're agreeing to and it actually works for you and your business. Number two, make sure it's tailored to suit your needs. So as mentioned, there's quite a fair bit of scope to get creative here. So if you have a particular concern or request, then perhaps you have the upper bargaining hand at the negotiation table. Make it known. If you don't ask, you don't get. And finally, just check that this model actually works for you if you are trying to get yourself a turnover rent. Remember the JD Sports case, would a market rent actually be better? Perhaps you can negotiate something that's actually going to make you more savings, so an all-inclusive rent that includes service charges, or a service charge cap, particularly at the moment going forward. Landlords looking to make energy efficiency improvements to buildings might be trying to claim those costs back via the service charge, so it could be a better cost saving for you as a retailer tenant. If that's left uncapped, it could be quite a hefty fee. And worked examples, I always recommend running a worked example just to check that it actually is the right thing for you, better worst case scenarios, just to check how it works in practice and what it will look like going forward. So that's everything from me, and I'll leave on that list. Hand over to Francis.
Thank you. You might be thinking, well, now for something completely different. And one very big thing working common, and the two biggest costs on any balance sheet, whether it's a one-store operation or whether it's a massive enterprise. So it's very, very much important to understand structural remuneration and also business by attracting people. So, when Stephen asked me to talk about this, I agree, and I began to sort of consider the topic. And I thought, well, I better make what you know. And then I realised the enormity of what I've actually committed to. So, how do you define what the fashion industry is? I mean, that would take the 10 minutes I'm allotted alone. Fast fashion, luxury fashion, we've got online, we've got retail, we've got wholesale, we've got, over 500,000 people working in the industry at all levels, and, goodness me. So what I've tried to do is to start by setting the scene. And so, excuse the glasses coming off and on, but they're very kind of put the notes over the other side there. And I can't see that far in these glasses. Terrible thing. So I'm sorry. It's one thing I always tell people not to do in presentations is keep taking glasses off and on and but where I thought I would start is actually by talking about the market trends that influence the need to develop strategies that are geared to attract and retain. Should have done that. I can't see them changing massively or not. And all of these things, although we're sort of concentrating on the most senior population, all of these trends and all of these thoughts are actually very relevant to every member of staff that you employ. It's just how you actually reflect in the conversation that you offer. So the first thing that's really high on the list at the moment is the whole ESG agenda, actually an organisation needing to reflect what's going on in the external climate with regard to the on the social impact and the environmental impact of that. That leads in turn to sustainability. So whether you have an organisation or whether you're connected with organisations, whether it's supplier or sourcing or relations to the circular economy, actually people care now about recycling. And it's very important for many senior executives in particular that they are associated with an organisation that that does right in these areas, and that's an attraction in itself. I was listening to our reputation management specialist talking the other day, and one of the examples he used was how quickly a reputation was destroyed by a fashion retailer, being now an online fashion retailer. I'm not sure if there's anybody here from there, by being suddenly outed and sourcing from what were seen as in unethical conditions, poor pay, and very high margins. So people care about that, and that's an external impact. And then we've got inclusivity and diversity. I mean, I know they've been around a while, and we talk about this all the time. But people want to be part of an organisation that really does have inclusive policies. And when we think about diversity, we're not just talking about gender or ethnicity. We're talking about things as diverse as age. We're talking, I mean, old and young. Often young people can't get a break, or younger people can't get a break because they haven't got the experience. Equally, older people like myself who need glasses to read their slides, might not be considered because maybe not on trend. We're talking about things like disability in all its context. I currently have amongst my clients a retailer actually, and he's visually impaired. And you kind of wouldn't know it, but he's spent his whole life, at director level in organisations at the moment, having to negotiate around the fact he couldn't sit here and do this, for example. He had no peripheral vision. So, being part of an organisation that recognises diversity in all its forms, encourages it, and is also inclusive is another key to attracting and retaining. And then we've got the whole well-being. We used to just talk about, work-life balance or whatever it is, but now we've got the whole range of, are we considering people's mental health? Are we considering the environment that they work in? The furniture, the way they sit, whether they're able to go in and out, whether they have access to shops or to childcare or whatever it might be. Then, of course, we've got the shortage of talent that's been referred to. And, again, that operates at every level. We have to think about shortage of talent in functional areas as well as what might be considered creative areas. So, probably logistics and distribution are one of the key areas that make a business work or not work, particularly in fashion when people want it, they want it now. So, you need to think about that right away across the board. We need to think about working practices, good old hybrid working and flexible working, and people being able to do things their way. But we also have to think about 24/7 environment and online and digital. We have to think about economic trends and ownership. So, for example, Stephen and I have talked about this in relation to private equity owned businesses or businesses that have investors who want to return, but also to attract employees to work in those businesses. You need to think about the equity that they might require with those in the moment, and the good old digital market and how that also, particularly the fashion sector at the moment. And then, of course, many people care, particularly at senior level, they care about their personal development and their career development as well. They want to get something out, they want to add value to their CV, and you want to prevent what's known as talent leakage in the trade. You don't want people leaving because they feel that they can't develop and grow to get into the C-suite or the boardroom or on the sector. So that's really a scene set, and say that in itself could have taken the whole sort of 10, 15 minutes. Then the other key thing to consider is whether you can have a single reward strategy that applies to all of your talent or senior talent, or whether you actually need to have tailored strategies according to, as I say, either function or I would use the word loosely, creativity in terms of perhaps people who are the face of the brand or the CEO. How do you cater for personality, and that's particularly the case at C-suite level, versus having to across the work. So here you need to think about, can you have overarching policies, or should you have a business unit focus, for want of a better word, be described in many ways. Should they be functional strategies, or should they be quite complex strategies that you can tailor to which particular circumstance? And then how do they need to be related to the workplace? Now that may sound funny, but people in functions, whether it's finance, whether it's HR, whether it's distribution, whether it's a function that, if you like, can be taken outside the industry, are a different workforce. So a CFO or head of accounts or a senior sales or relationship manager or whatever it might be, even a brand manager, those are transferable skills that wouldn't necessarily be related to the fashion industry. So perhaps they need to be treated, and your strategies need to be related to external employers as well, outside the industry. And so you're competitive with those. People who perhaps are, as I say, names or up and coming names, people who are doing your digital, people who are doing your website, people who are your creatives, people who are your graphic designers, they will tend to be industry focused. And again, you then need to relate everything you do to other industries or to other people who might be who they might be comparing themselves with. Then we've got good old global, regional, or local. Probably best to leave that up there just as a point. But should you have a local strategy for reward related to where you are? Are you in the scenario where people are going to be very fluid, or they might be working across a region, or they may have global roles, or near focus roles, or whatever it may be. And then obviously we need to think about whether it should be, say, innovative, where you want to make the running, or whether you want to be matching market. And sometimes the best place to be is innovative, because if you break the mold, it's easier to have a creative and attractive reward strategy than actually always trying to say, well, we're the same as so and so, or our group has similar policies to this group. And then say, should it be competitive, or might it be creative and much more performance related, either individual performance, market performance, or organisation performance? Right, I think I might even be able to do this myself. So finally, I thought let's have a look at the reward package and how that might structure, and also think about those rewards that are actually tangible. In other words, the ones you can feel and see on your payroll line, and those that are actually intangible, but are probably the most important thing at the end of the day in order to structure a. So in terms of tangible, salary obviously is the first place you start, and then the benefit. And again, benefits are anything that any financial benefit I'm referring to here. So that could be anything from pension to healthcare to childcare or whatever it might be. And it could be that it's also related to things like a discount. So actually, the advantage of being part of a particular group and being able to wear that brand goes, which might not be accessible. I know when I nip down to Chanel, as I occasionally do, I mean the office of the best shop. I can see a wonderful bag on the desk, and I think, oh, one of those. And obviously, part of the employee benefit that they're able to buy the bags or the clothes or whatever it is at the price. Then we've got good old bonus. And bonus can be structured in a variety of ways. It can be done on a percentage basis. It can be done on a performance basis, individual basis, or it can be a combination of personal performance and organisational performance. So again, you need to think about how that works in your organisation, because for some people, it's okay to be measured by the company's overall performance. If you have no influence on that at all, actually, it's very demotivating to think, but my area, I did, we met our targets, or we achieved our margins, but we don't get the bonus because the rest of the business didn't. So, but quite an important one to get right. And the same with incentives. An incentive could be related to a long-term incentive. So it might be a share program, might be a incentive to increase profitability in a certain area. It might be an incentive to introduce a transformation program or something like that, within a specified period. Ownership, what I'm talking about there, refers to the one below as well, is that you might have benefits related to, for example, John Lewis partners are effectively, part owners of that group, and there are a number of other retailers, that would have similar. But it might also be that, you're a part owner of maybe 2 or 3 of you that started up a chain. Almost every single fashion brand in the leisure industry seems to have been founded by 2 or 3 people out of Salcombe in Devon, which is actually where I live. And everything from Blackface to Jack Wills or whatever was originally founded by a couple of people. And then you think about rolling that out and then things becoming a much bigger empire, and how that impacts on where the owners sit in relation to the functions around them. Very often owners are very good at founding things, but they're not very good at making them work once they become corporate and ongoing. So you need to think about how you create ownership amongst your wider employees as well. Equity, I'm referring there to private equity backed businesses or where, you may find that you're offering people lower salaries, but significant. We have a lovely term which I've definitely adopted as my own, called personal wealth creation opportunities. And I think actually that's the key in many senior employees' minds, is actually, I want to do this, I'm passionately committed to it, I love this industry, I love this, designing shoes or bags, or I love getting out there, but actually I also want to get something from this. So it's a good thing. And then other, as I say, sort of smaller but quite important benefits are things like childcare. And that's not, again, most people say, oh, well, that's only for women, but it's not, is it? Very, very often, an employee male will be caring about whether there is childcare or nursery fees or anything that relates to children or whatever. And then, of course, good old holiday. So those are the sort of tangible benefits that you think about building into being an executive package. And you need to decide, as we said on the previous slide, whether those are things like market match, or whether you try to be innovative and make them your own and your own policies. But the really, really important things, and sometimes the things that cause us to lose people or not attract that we would like, is that whole positioning of the intangible and the intangible reward. So not when I say environment there, I mean two kinds of environment: the working environment and the working conditions, and that also relates to the culture and values. But also, actually, are you an environmentally friendly organisation? Do you genuinely have concern for sustainability? Are you focused on, again, another interesting webinar we were running the other day was on green finance, whether that was a fact or fiction. So we're not just talking about is your packaging sustainable or whatever it is, but are you doing good through the way you utilise your financial as well. Obviously, people want to know that they have enough leisure time. And again, when I the more friendly employer, sorry, that goes through more patterns work as well. But you'll see all sorts of things, whether it's the ability to have a gym in the building, to I know my daughter has they come and do manicure, at desk manicures and massages, and stress busting things and whatever. So well-being is pretty important, and we need to think about our well-being in every respect too, because jaded, tired senior executive is not somebody who's going to perform well for you. Give them a chance to look after their well-being. When I say community, again, it's the spirit of the organisation. You need to have an organisation, however small or however big, that has a community and a spirit that you want to be part of. It doesn't mean all the people who work in it are the same, but it does mean that you need to have a culture that people want to, they want to enjoy their work. We often say, we spend far more time at work than we ever do at home, particularly at the top of the organisation. So we sure as hell, deserve to enjoy it, and just feel, part of the community that supports us, that we're proud to be in. The personal growth agenda I mentioned briefly earlier, but it is important for people to have a career path, even at the most senior level. They want to think about, for example, how they might move function, how they might, raise their profile, how they might perhaps move to another market. So that's really important. And career development in every respect. Soft skills, not just hard skills. The people will often say, I was looking to go on 3-week course at Harvard, or they bring in people to work with us on developing skills. And also they somebody recognizing, again, I would be proud candidate, technology, for example, and actually being, changing, and people don't often know. I mean, I'm going to be fascinated here about the NFT bit, actually providing education in that time. And then we talked about flexible working, diversity and inclusivity, and cultures and values. So really, the takeaway that that I would say for you is that in order to provide a truly competitive package at every level, what you need to do is to make sure that you reflect all of the trends that are relevant and important to attract, but more importantly, to retain those people who are vital to the health of the organisation. And whatever you need, whatever you do, it should always be top down, because the person at the top is the person people look to, and if they feel that this person doesn't reflect the values, or this person is over rewarded, or whatever it is, and the rest of us are not, again, it's not a happy ship, and you're not going to get it. So, we're talking about being competitive in the marketplace at every level, not just salary, not just tangible benefits, but the environment and a community that really resonates with everybody in your organisation. So, a quick contact. You took the world with what you need to consider. They just the most important.
Moving on to the scary topic of director responsibility. So I'm going to be talking about 10 ways as a director you can be held personally responsible for actions of the company. So it's a well-known fact of English law that a company has its own legal personality and is therefore separate and distinct from its shareholders and directors. Therefore, a company shields its members and directors from most liabilities. So you can see on the screen, the people are the members, shareholders, and directors, and they are shielded by that roof from any liabilities or claims that might be brought against the company. The directors, that protective veil can be pierced or broken in certain limited circumstances. And I'm going to take you on a quick whistle-stop tour of 10 ways that can be done today. Firstly, not acting in good faith. In a recent case, a director of a company was held personally liable for inducing the company to breach an employment contract as he was not acting in good faith in relation to his duties towards that company. The key point when the court was assessing his liability was whether he acted within the scope of his authority. So the focus was on the director's conduct and intention in relation to his duties towards the company, rather than his responsibilities to the third party, so the employees that he breached that the company breached the employment contract of. So it's really important that as directors, you make sure that you fully understand not only your statutory duties, so your director's duties under the company's law, which I'll get to later, but also what other documents such as shareholders agreements or your articles of association say. Second, personal guarantees. So when companies take out loans, sometimes directors are asked to give personal guarantees. These are often requested by banks to give the bank the maximum protection for any loan taken out by the company. So, for example, if you took out a civils or coronavirus loan, you might have given a personal guarantee. It's often easier for the bank to pursue an individual who has a guarantee than to enforce its security against the company. If this is the case, then the director is making themselves personally liable if the company is not able to repay the loan. So, for example, if you have a house, that could become exposed to the bank. A director's liability in this situation can be limited by, firstly, not giving the personal guarantee at all, but this will really depend on your negotiating power with the bank, or putting a monetary limit on the guarantee. So, for example, say you're only liable for up to £10,000 or whatever the amount of the loan is, or linking the guarantee to a specific obligation, like a specific loan. So, not all sums that are due and outstanding to, for example, HSBC. Companies' house filings. I think often seen as a boring administrative task, but good to know that as a director, you could be liable for a fine of up to £5,000 if your company doesn't file their accounts within a set time. Directors can also be held liable to the company for any loss caused by the making of a misleading statement or anything that's missing from the filing. That's just an example. There are other sort of fines that directors can be personally liable for today. Fourth, wrongful trading. So wrongful trading comes up in an insolvency situation. So if your company goes insolvent, and it goes into is insolvent and it goes into liquidation or administration, and you as a director knew or ought to have known that there was no reasonable prospect of the company avoiding insolvent liquidation, and you fail to take every possible step to avoid further potential loss to a company's assets or its creditors, you could be held personally liable. So if the court decides that this has occurred, it can order the directors to make appropriate contribution to the company's assets. Directors' duties under the Companies Act, I mentioned these earlier, and they're all listed on the screen, so I'm not going to go through all of them. But if a director wants to breach any of their duties set out in the Companies Act, so for example, their duty to promote the success of the company, they could be held personally liable pursuant to something called a derivative action, which is when shareholders bring a claim. A derivative action, as I just mentioned, is where a shareholder can bring a claim on behalf of the company, and the director would need to make good any loss caused by their breach. Number 6, getting through these quite quickly, which is good. Health and safety legislation. So directors can also be liable for company failures of health and safety. I think if this legislation applies to you, so for example, in a factory, then you would probably know, or you should know. Under the Health and Safety Works Act, if you're found to commit an event, director can be liable for an unlimited fine or imprisonment for up to 2 years. In cases involving fatal accidents at work, a director can be found criminally liable for involuntary or gross negligence manslaughter. So really important to have all of your health and safety ducks in a row. Statutory declaration. In an insolvent liquidation process, so this is where shareholders no longer want to continue a business, directors can be held personally liable if they make required solvency statements that the company is liable to pay its debt in full in the next 12 months, and this turns out to be untrue. If this is the case, then directors can be liable for an unlimited fine or up to 2 years imprisonment. And if the declaration is not registered within the 15-day requisite time period, both the directors and the company can be fined at an aggregate rate for each day if not filed. So really important to make sure you meet all of your deadlines. Number 8, Phoenix liability. So it's an offence for directors to reuse an insolvent company name in a new venture. The test of this offence is whether the name of the new company is so similar that it will cause confusion to any creditors of the dissolved company. If these requirements aren't followed and the new company fails in the preceding 5 years, the directors can be held liable for debt of the new company. And if there's more than one director, both directors be held. Number 9, vicarious or assumed liability. So lots of signature blocks on the screen. You've got to be really careful when you're entering into contract as to whether you are entering into the contract in your own personal capacity or on behalf of a company. In a signature block involving a company, you'll often see the wording for and behalf of excellence, for example, on the screen, under the director's signature. This is used to indicate that the signatory does not intend to be bound personally, but failure to do so, for example, if you sign a signature, the second signature block on the screen saying John Smith, would mean that John Smith will be deemed a party to the contract and therefore personally held liable for any subsequent breaches or any obligations under that contract. So it's vital that as a director, you set out your deliberate intention to signify on behalf of the company that you're entering into a contract on behalf of the company rather than as an individual. Finally, tax evasion. HMRC in specific insolvency circumstances can hold directors jointly and severally liable for tax or tax penalties. So this liability was introduced to ensure that individuals are held liable for bad behaviour and for HMRC to recover the full amount of any tax liability or penalty that companies are affected by potential or actual insolvency. So concluding remarks, some practical tips. Even if a director is held liable on some of the points mentioned today, there may be ways to mitigate or limit the loss caused to that individual director. So this can be achieved by obviously taking legal advice and considering a couple of other factors. So first of all, considering whether the company has directors and officers liability insurance. So I think D&O insurance is something that's quite common for companies to take out. So good to look into that if you're ever found to be personally liable. Looking into your company's articles of association, which are the rules of the company, to see whether there's any specific indemnity for directors to be compensated by the company for, anything that they take on. In certain situations, checking the contract to see whether there's a right of contribution. So, for example, if you've given a personal guarantee, checking if the bank could enforce that guarantee against other personal guarantors. So they have money or assets with you. And then finally, whether there is a claim for subrogation. So fancy legal word, but it's basically where you as a director are able to enforce a security that the bank has, so stepping into the bank's shoes to enforce the security.
So I'm starting to see a common theme tonight. It's not just fashion, but it's complex topics that have to be condensed into 10 minutes or less. So a health warning during this talk. There's no real NFT legislation to say that I can discuss that specifically. It's more an overview of the issues that you run into if you're looking to launch an NFT collection. So it will cover quite a broad range of topics. So apologies if it's a bit ocean wide, paddle deep, but I just want to make people aware of the things that they should consider when looking at NFTs. So I will be looking at the commercial issues that can arise and things that you should think about before launching an NFT collection, then IP ownership and the rights associated with that. I'll also look at commercial contracts with third parties and with your customers as well, and also a relatively high level overview of the regulatory issues that can arise when you're launching an NFT collection. It may be helpful to demystify what an NFT is. It stands for a non-fungible token, and it's a digital type of asset. Fungibility is maybe best explained if you think about something like a pound coin. £1 coin is almost indistinguishable from another pound coin. If you lend me a pound coin, I can give you any other pound coin back. It doesn't really make a difference. If we're talking about assets like a house or a car, those are non-fungible. You can easily exchange those for one another. And the same can be said about NFTs. So where Bitcoin or Ethereum are fungible, they can be exchanged. NFTs, whilst you can trade them with other people, they're not as easy to exchange in a value sense. And examples of successful NFT collections that have been launched recently include the ones that are up on the screen right now. You've got the Tiffany CryptoPunk pendant and the Artifact Nike collection. So Tiffany's allow CryptoPunk holders to exchange pendants or to purchase pendants, I should say. And the Nike collection, you can use a Snapchat filter to see your virtual clothing in real life, quotation marks. So what do you need to think about? The first is, and some of these points actually picked up from a recent conference I attended called NFT London, is really don't launch an NFT collection for NFT's sake. Actually try and come up with something that brings value to your customer base. What do your customers want? What do your followers want? Do they want exclusive access to merchandise? Do they want some loyalty rewards or exclusive collections? That's something you should be aware about when thinking of entering the space. You also need to be sure that you're authentic. Work with experts in the field, specifically NFT or Web3, to ensure that you're staying true to your brand. Don't dilute your valuable IP, something that you may have spent years building up, just to rush into the NFT space. Make sure that you're staying true to your values. Another really important aspect is being customer centric and focused on what your audience wants. And that goes both ways, not just focusing on what they want, but using things like Discord or social media to understand their feedback in relation to your project. They want to be involved in the design process often. And if you use them, they can be a really powerful tool at bringing value into your collection. Then following on from that last point, you need to keep your audience engaged. So you can use promises of tiered membership within your project to allow people to have access to more exclusive NFTs or in real life clothing drops that are only available to people who are actively engaged in your ecosystem. And to say 100 engaged users can go a lot further than 1,000 inactive ones. So really focus on ensuring that your audience is captivated by your project. And finally, in terms of commercial considerations, don't overpromise and underdeliver. Nothing is going to affect your brand's PR more than a project where you promise the star and moons and the stars and moon, I should say, but actually have delivered very little of value or utility to your customers. Okay, so you've thought about the commercial things before venturing into the space. What kind of IP considerations should you think about before looking at NFTs? If you're an established brand, then it's probably something you're familiar with, IP rights, registration, and any issues. But if you're not, it may be useful to go through the following checklist. As a starting point, look what other projects are out there and are they doing anything similar to what you're thinking of launching? Because if they are, then you may have issues going forward even before you've begun. You also need to look at whether or not you're basing your project on the works of contractors or employees. You need to ensure that as a business, you own the intellectual property rights in the work that you're doing. If it's an employee, usually employment contracts deal with IP ownership, and if something's done in producing the course of employment, then the company owns it. but there are important considerations in this right that you need to think about. But in addition to that, contractors and artists, if you're commissioning someone to produce the artwork for your project, you need to make sure that IP is dealt with there. And even more risky is if you're basing your IP on the work of a third party without having spoken to them, because there are a few misconceptions around making only a small amount of changes to those works will be something that can get you off the hook for copyright infringement. You can't say also that you're making a homage to someone, because that's unlikely to pass the test. So you need to be really careful when thinking about starting and creating IP for NFTs. All right, you've thought about some IP concerns before starting a project. What about once you've actually started? What kind of rights will arise, and do you have to be aware of? There's copyright, which is the easiest right to get because it arises automatically, essentially as soon as you put pen to paper. But the work that you create has to be novel and in a tangible form. It lasts for the life of the author, around 70 years, but there's some computer-generated work that's only 50 years. And also, a really good thing is that it is recognized in jurisdictions globally, although all the relevant laws have their own specific quirks and particular things that may differ from jurisdiction to jurisdiction. For instance, in the UK, you have something that's known as moral rights, which belong to the author of the work. And in some cases, the author of the work may be different to the copyright owner. This right allows the author to be identified as the creator of the work, to object to derogatory treatment of the work, and to protect the work from being falsely attributed to another. So it is possible to waive this right, but it's something that you need to discuss and agree beforehand. In terms of the infringement of your copyright, there are two ways someone can infringe it. The first is primary infringement. That's where they do something that you have the right to do as the copyright owner without your permission. And then there is secondary infringement, which is somewhat further down the supply chain, where, for instance, in the context of NFTs, let's say an NFT marketplace is dealing with infringing NFTs with that. But the importance here is that to be a secondary infringer, you have to have knowledge that the work is, or ought to have knowledge that the work is infringing the intellectual property rights of another. And the remedies for infringement include you can sue someone for damages. You can request an account of profits for any profits derived from those works. You can try and file for an injunction, which will prevent someone from using the works. And you can also ask for the destruction and delivery of those goods. The example on the screen, actually, it's not as simple as it seems. Tarantino this year launched an NFT collection, believing he owned the rights to some unreleased fiction screenplay. And actually, he was sued by Miramax, claiming that he had assigned the rights to them, and they settled out of court. So it's actually something that some people may take for granted, but you do need to think about. All right, so copyright is an unregistered right. The first call for registered rights is trademarks, and they essentially allow you to have a brand or logo that can distinguish your company and your goods and services from that of your competitors. And the benefits of registering for a mark is that they give you the exclusive right to use that mark for goods and services in the classes that they're registered. It's a tangible registered property right, so it's much easier to license and assign. And also, if you're thinking of selling your brand, then it can give investors a lot more confidence in registered forms of IP. It also gives you the right to sue people if they infringe on your trademark, and that's for using it in identical or similar, an identical or similar mark for identical or similar goods and services. And because the trademark register is usually public in most jurisdictions, it can also thwart other parties from infringing your rights, because if they carry out a search, they may see that you're the trademark owner. And the remedies afforded to trademark infringement and suing for it are similar to those that I mentioned for copyright. So this can afford you quite a strong defensive weapon in case someone is infringing your rights. Okay, you've considered your rights and your IP, so what can you actually do with them? You need to consider licensing and the terms and conditions for your NFT project. Licensing will typically deal with the intellectual property rights, the commercialization of the NFT, and also termination of those rights. This should also be covered in your terms and conditions. It's important for this reason to understand who owns the intellectual property, because you shouldn't be licensing something you don't own, and you have no right actually to enforce any of those rights if you're not the owner. Or even worse, you may find yourself at the end of a lawsuit by the true owner of those rights. The benefit of NFTs is that, at least at a smart contract level, which is the thing that deals with the underlying token, you can incorporate an automatic payment of royalties into NFTs once every transaction is made. Although this is the gold standard of things, it's not currently the industry standard because there are a few complexities that I won't go into now. But if you're not dealing with royalties at a smart contract level, then you should be dealing with them at a commercial contract level, and make sure that the payment of royalties is, and how they're paid and when they're paid, is addressed. When you're preparing your license for your NFT, you want to be clear exactly what you're doing with the IP. Are you assigning it to the purchaser of an NFT? Are you simply licensing them to use it for personal reasons or commercial reasons? You just need to be clear that if you're assigning all the IP rights, that the IP rights will be retained by whoever holds the NFT, because if the first purchaser of an NFT then has the unfettered right to hive off the IP rights, they can then sell their NFT to someone else, but keep the IP rights for themselves. So you want to avoid that. Make sure it's clear that the NFT holder is the owner of any assigned IP rights. If you're only licensing them the rights, then you need to be clear as to what kind of rights they have. If you just want them to be able to use it as a profile picture or something on Twitter, then be clear that that's all you're letting them do. If you want them to be able to commercialize it, you need to give the specific details. Is there a limit on how much profit they can make using your artwork, or is it unlimited? Is it something that when they create derivative works using the IP, the ownership of those derivative works belong to the person creating it, or do you still want to retain some interest in those works? Again, this is all something that you need to cover in both your terms and in your licenses. Another thing that you need to be really clear about is what happens when someone breaches your license or your terms and conditions. And you also need to know how to enforce that. So a lot of platforms like OpenSea allow you to submit takedown requests for people infringing either the terms and conditions or your intellectual property rights. Of the things that I just mentioned, whilst these were maybe B2C, you need to have similar considerations if you're doing a B2B transaction or entering a B2B contract. So if you're looking to list your NFT on a marketplace, You need to make sure that they have the proper licenses dealing with IP and the proper commercial contracting terms as well. The final area that I'll be looking at today is a very brief overview of the regulatory issues. Because most NFT sales are sold to individual consumers, you will have to deal with consumer-related regulations. Of course, consumer rights, be clear exactly what you're promising to your customers, because, and this goes back to what I said earlier in the talk, if you're telling them that they'll get X and they don't get X, they get Y, you could be in trouble. Similarly, it's not on the slide, but if you're dealing with consumer personal information, data protection issues are certainly going to arise, and that's something you need to think about. From a financial services perspective, there are a few key areas that are worth considering. If your website or project allows people to pay for the crypto, the token, the NFT in fiat, you may be considered an exchange by the FCA. So you will have to register for anti-money laundering regulation and registration. And it's a very onerous process. It's called registration, but it's more akin to authorization for a regulated activity. Similarly, if your platform or website allows people to hold fiat money in a digital wallet, you're likely to be caught by the e-money regulations. So and those are very onerous and have significant penalties if you're found in breach of them. One that is a very common theme for NFT collections is securities regulation. So if, for instance, you're selling an NFT with a promise that by being a holder of this NFT, you can earn money on generated income through secondary sales or some other sort of benefit in the future, if this is advertised at the time of you selling the NFT, you may be caught by securities legislation because there's a promise of a future benefit by purchasing this specific asset. The one that's less commonly thought about is the fact that you may be caught by gambling legislation and regulations. If being an NFT holder, which often they do, provides you with a perk, and sometimes these perks are you're part of a lottery to win prizes, be they big or small. Some may be additional NFTs, some may be payments in cryptocurrency or access to exclusive events. You actually may be caught by gambling legislation because it's somewhat akin to a lottery. So you need to be very careful when you're entering the space that you're not falling foul of these legislation, because some of them actually hold criminal convictions for the company, and in some cases, if the corporate veil is pierced, then you may have director responsibility as well. So I've gone through those areas quite quickly and at a relatively high level. What are the key takeaways and practical steps that you can keep in mind? Well, make sure that you're keeping records of everything. That includes your intellectual property, your commercial terms, and your licensing and how you've approached building your project, as well as your customer base. Consider registering those IP rights where appropriate. Trademarks can be registered in various jurisdictions. NFTs tend to be global ventures, so this could require a global approach. When you're dealing with entering into any forms of commercial contracts, make sure that they deal adequately with the type of NFT collection you're seeking to make. Make sure that they deal with who retains IP and how royalties are paid and calculated and what can be used in relation to your NFT, both during the course of the agreement and post-termination. And then also, importantly, make sure that your terms or your agreements are crystal clear if there's a breach of any of the terms, because the last thing you want to do is to try and enforce a right that you don't have, and then you'll find yourself in a sticky situation where you may be left holding the bag whilst the other person rides away into the sunset. So those, I think, are the key things to look at when launching an NFT collection, and that is moving on to the Q&A section, I believe. Oh, slides.
We are indeed done. Thank you very much. Right, you've been very patient. You've listened to our 4 speakers. Now you have the opportunity to turn the tables on them. Are there any questions for any of our speakers? Ian?
Yes, Rebecca, I'm confused about JD Sports
Oh, yeah,
case you said.
yeah.
So JD Sports and the landlord entered into a negotiation where neither of them knew the account's information. That's essentially what you're saying,
Seemingly,
because
yeah.
and right, okay.
I'm confused as well.
So I've missed something here. Okay,
No,
right.
no.
Thank you. It's just remarkable. It's on a turnover basis. JD Sports was acting on a doesn't have the record. But, okay.
I think at the time the market was so turbulent, 2017, that they pinned the rent to, that you have the status quo, you're happy with the status quo, and you think it's working for you, and you don't think, hang on a sec, is this actually where the market is now? And I think it was a tenant's market at the time, and the thing to be cautious with, I suppose, is they were still negotiating the rent 4 years later, but you have to pin it back to 4 years ago and what they could have got at the time. But no, I don't know why they decided to change their position, but good job for JD.
But I think
Take advice, get an agent.
But I think it also goes to show that at that time, I think JD Sports was FTSE 250, remember? And it goes to show that even companies of that size can do things which cause amazement. And that does cause amazement. It should have found itself in that position. Jerry, yes.
Rebecca. No, I wanted to know whether you had any experience we could share, basically the difference between maybe having a turnover rent with an independent retailer, maybe a 1 or 2 store operation versus a chain store, and maybe specifically in relation to, the duration of that turnover contract. And maybe the other aspect would be, the notice period before they break the contract. And there's a side question, because you mentioned, the benefit would be for people to ultimately try to work together to improve, of course, the money they're going to get from the turnover rent. What kind of action the landlords are taking to actually improve profitability with the retailer, if anything?
Yeah, so on the sort of smaller retailers, the experience we have really probably more acting for the landlords in these scenarios is, I think, as I mentioned, it's just difficult to pin down what the accounts actually look like and to track that from the landlord's point of view, whether they can have the technology they need to get all the information they need at the point of sale, and then make sure that it's accurate. In terms of notice periods, it's all a point of negotiation when you enter into the lease. So it might be that the base rent starts at X and then incrementally increases, or there's an upwards only review of whatever the turnover was from last year. So that sets the next year's turnover rent that's payable. I think I mentioned also landlords might be looking to be able to get out of the lease early by inserting a break right for the landlord, but you'd also have the same for tenants. So they might decide, well, I don't know how this is going to go. Do I really want a 10-year lease? They'll then have an exit option, providing they comply with certain conditions where they can then leave early if it's not working out for them. But that all has to be negotiated right at the outset when you enter into the lease. Once you're in it, it's just a get what you can if you need it, but you can't insert any rights once you've entered into that lease. Don't know if that answers that part of the question.
The question was afterwards whether they are actually trying to be proactive in supporting and trying to make sure that the retailer does the best job to improve sales.
Yeah, so I think this we see it more in the bigger shopping centres,
Sure.
where the landlord can use the data they get from the tenants to maybe assess footfall and see where customers are landing more often, and then they can perhaps rearrange their stores, if possible, to make sure that it makes the best revenue for the centre in itself, or perhaps they might spot some blind spots where customers aren't going. So just the collection of that data itself helps them, the landlord at least, to look at the other amenities they have in the area, and it then just helps everybody to have be more profitable. And it's I suppose then down to the individual landlords and tenants as to how good that collaborative relationship actually is. You can still get adversarial, especially if you've got these provisions that one or the other isn't able or isn't prepared to comply with.
Would it be indiscreet to ask you, would some of them try to actually look at the operations side, meaning the way they manage the business, the way they look at KPIs and all that?
As in landlords looking at tenants. I mean, not that I have experience of, but I think there is a level of scrutiny that a tenant can object to. If it all depends on what you put in the lease and what rights the landlord has. I say the more bullish and the bigger the landlord is, if they're dealing with smaller independents, then it's easier for them to say at the outset, actually, I want to be able to do X, Y, Z, or put it in the lease. The tenant hasn't really thought about it and has agreed to it, and then perhaps the landlord has a better bargain position or already has that ability to look further. But other than the actual accounts, there's not really any ability for them to walk in and say, you know, put this clothing rail over here, please, because it's not selling over here.
Yes.
I was just going to add, I work with FM, so similar experience. I was just going to add that we've been working on a couple of projects at the new Battersea Power Station development, and there the landlord has been quite sophisticated. I don't know if you've been down there, but there's premium brands, large brands, small brands. And the landlord, as Rebecca said, has been quite proactive in positioning the brands that haven't perhaps got the volume in terms of other stores next to other larger, more attractive brands that might have a higher footfall. So they're very carefully managing the turnover, essentially trying to achieve the most for smaller tenants as well to get the best out of their rental. And in addition, they've got footfall monitors as you walk through the door, so they know exactly what's coming in. And they're engaging you in getting involved in management meetings. So I suspect as that goes on, they'll be talking to you about, you've had X amount of footfall, same as X brand, they're making more in terms of turnover, what's going on, how can we help you? And I think there'll be a lot more of that goes on as time goes on.
That would be smart.
Any other questions? Yes.
Yes, a question for the landlord in respect to how you view the current British legal state for NFTs and payment by crypto, and what is currently legal and what changes you would foresee coming to UK on whether or not these companies are going to remain offshore where they don't have to worry about any scrutiny at all.
Interesting question. I think the UK is very good at saying that they're going to be market leaders in a lot of things, and sometimes not so good in making quick and swift changes compared with other jurisdictions. I know that the current government has been at least portrayed as very pro-crypto, but has yet passed any legislation to actually substantiate that. So from the UK legal system, it's still a matter of applying existing legislation to the realm of what is currently going on in crypto. Some of those are, like jigsaw pieces, they don't fit very neatly, but at this current point in time, they probably do cover most of the areas. the issue is that sometimes consumer protection is not where it needs to be, and some of the regulators don't want to touch it right now, either due to resources or due to the fact that it's such a novel area. I wouldn't say, though, that because they're not those adequate legislative protections or statutes that they don't apply to offshore outfits, because for instance, some of the financial regulatory legislation will apply if you are selling your product or services to the UK, or specifically UK customers. So regardless of whether or not you're based in the Caribbean or in the Middle East, you're going to be affected by specific types of regulatory things. But the question then is whether or not it's enforced. Enforcement is somewhat lacking because of resources, and like I said previously, because I don't think they're ready yet to face the current crypto market. So in that sense, the UK, I think, has a lot to learn and to initiate. But if the words are not hollow, then potentially they could actually become one of the leaders in the market if they actually start to take the legislation side of things more seriously. Hopefully that answers your question.
There's many more.
Can I suggest, because I'm conscious of time's ticking on, if we draw those there, we adjourn next door, and then that may be the subject of further questions. Everyone should have then in their packs an assessment form. Please do take the opportunity to complete the assessment form. Your feedback is always very useful to us. And if you just leave your complete assessment form whatever you want to, it will be corrected in. I can assure you of that. But subject to that, I'd like you to join with me in thanking Rebecca, Francis, Jimway, and Brad for very illuminating talks this evening, thought-provoking talks this evening, and in some respects, particularly when it comes to direct responsibility, worrying talks. So thank you all very much indeed, and please do join us.